Hello. In the following, I would like to present to you some procedural aspects about filing of a demand for international preliminary examination. So first of all, I would like to discuss what is international preliminary examination. Then, who is entitled to file such a demand? Where do you need to file it? What is the applicable time limit to file a demand for international preliminary examination? What are the signature requirements? And then, last but not least, I would like to actually talk about the form that you need to use, the demand form, to file a demand for international preliminary examination. Now, what actually is international preliminary examination? Well, maybe first of all some terminology. We talk about filing a demand for international preliminary examination, but since this is such a long word, a lot of applicants and users have turned to just calling it a demand under the Chapter 2 procedure. Now, why under the Chapter 2 procedure? Because basically the PCT treaty is divided up in various chapters, and Chapter 2 deals with international preliminary examination. So if you want to keep it short, you call it a Chapter 2 demand. It's an optional procedure. It's one of the few procedures under the PCT which is actually optional. So applicants need to take a conscious decision whether they wish to go into this part of the PCT procedure. If they do, they file this demand, and with filing of the demand, they automatically elect offices. They elect those offices which, at the time when the demand is filed, have been designated by the applicant. And of course, as you know, when you file a PCT application, you automatically designate everyone. So unless you excluded someone or you withdrew the designation of any of the contracting states, when you file your demand, you will automatically have all your designated offices now become elected offices. And this is really just terminology. Of course, they're still the same offices, but they turn from designated offices into elected offices just to show that a demand has been filed. The result of international preliminary examination, if you so wish, will be a preliminary non-binding report on the three main criteria of patentability, namely novelty, inventiveness, and industrial applicability, or sometimes referred to as usefulness. If you file a demand, this is the only opportunity for you to access the possibility to amend your application under Article 34. Under Article 34, you're entitled to amend all parts of your international application. So the claims, the description, the drawings. If you have a sequence listing, it could also be amendments to the sequence listing. Now, who can file such a demand? Well, it's basically you need to have at least one applicant who is a national or a resident of a PCT contracting state. So that shouldn't really be too complicated to comply with. The only case where you might wish to be a little bit careful, if, let's say, you have a single corporate applicant in your PCT application, and then you transfer or you wish to transfer the rights to another company, but that company is not a national or resident of a PCT contracting state. If you want to file a demand, be careful to not record this transfer until after a demand has been filed, because if you only have an applicant who's not a national or a resident of a PCT contracting state, that entity, that person would not be entitled to file a demand. Other than that, there really shouldn't be any problems in practice. Where do you file your demands? Well, you need to file it directly with the competent International Preliminary Examining Authority, the IPA. And which one is competent? Well, that depends on where you filed your international application. Because where you filed at that receiving office will have specified which IPAs are competent for international applications filed with that particular office. You sometimes have a choice, and be careful, depending on which authority you have chosen as an ISA, that might actually sometimes limit your choice later on as to which authorities you can choose as an IPA. For instance, the European Patent Office, they are competent IPAs for many receiving offices, but if they haven't done the search, and if you were able to choose a different office other than the EPO as the searching authority, they will not accept a demand filed with them afterwards, because they only want to do this in cases where they themselves has done the international search work before. Now, what happens if you end up filing with the wrong authority? That's actually not particularly critical, because there is a procedure very similar to the Rule 19.4 procedure, which applies when you file your international application with the wrong receiving office. Basically, under PCT Rule 59.3, the non-competent authority will either transmit the case to the correct, competent IPA, or they will transmit it to the IB for us to sort it out, and we then forward it to the competent IPA. And the good news is, in all of this, you will get to keep the date of submission with the non-competent authority. So if you're up against the time limit, you can rest assured that even though you filed with a non-competent authority, that date of filing with the non-competent authority will still be kept, even if the case later on needs to be transmitted to the competent authority. So what is actually the time limit to file a demand? Well, basically, there are two time limits. We like complicated time limits in the PCT. So again, here there are two time limits. It's 3 months from the date of mailing of the search report and the written opinion, or 22 months from the priority date, whichever of the two time limits expires later. Keep in mind that this time limit has a dual function. It's a time limit within which you need to submit a demand, but it's also a time limit that keeps the IPA from starting international preliminary examination until that time limit has expired. And the only exception to that is if you make an express request in the demand form that you want an early start of international preliminary examination. So why is this important? Well, keep in mind that the written opinion of the International Searching Authority will, in the majority of cases, will automatically be used by the IPA as their written opinion, which means they don't have to issue a second written opinion. They can straight away issue the final report, the IPRP Chapter 2, the International Preliminary Report on Patentability Chapter 2, without giving you as an applicant an opportunity to get an advance warning that there's still something negative in the final report. And since you will not receive a second opportunity to respond to a written opinion from the ISA, you really need to make sure that all the arguments and all the amendments that you need to make based on already the written opinion of the ISA and the search report are furnished to the IPA within a certain time limit. Now, actually, the time limit to submit these amendments and arguments is set in the PCT regulation in such a way that the rules say an IPA examiner does not need to take them into account when he already started to draft the final examination report. Now, of course, you as an applicant, you will not know exactly when that point in time is. It's an internal procedure. But you do know, as I explained earlier, that the IPA cannot start with international preliminary examination until the expiration of the time limit under Rule 54 bis, the 3 months and the 22 months, which I just explained earlier. So if you keep to that time limit, you know that you have a safe window in time within which you can submit your amendments, your arguments, and you can rest assured that they will need to be taken into account by the examiner at the IPA. So in conclusion, I was hopefully able to show you that filing a demand is not that complicated a thing to do. Be sure that you respect the applicable time limit and that you're also prepared within that time limit to submit all your arguments that you wish to make and all your Article 34 amendments. And with all of this, hopefully by the end of the procedure, the IPA is able to establish a more positive, if not fully positive, report with which you can then enter the national phase before the elected offices.